excited to be here on U of H's campus today. Of course, celebrating Black History. I'm here to see Dr. Ruth J. Simmons speak. If you don't know, Dr. Ruth J. Simmons is originally from Grapeland, Texas, but she moved to Houston, Texas when she was a young girl. She went on to be the first Black person to be the president of an Ivy League school. She also was the president of Prairie View A&M University. She is now Rice President's Distinguished Fellow, and I'm super excited to be here. So let's go check it out.
Dred Scott versus Sandford. Dred Scott was an enslaved African American. He had gone from a slave state to a free state, then he went back to a slave state, and he argued that he should be considered free. The Supreme Court in 1857, 3 years before the start of the Civil War, they found 7-2 that African Americans whose ancestors were imported into the U.S. and sold as slaves, whether enslaved or free, could not be American citizens and did not have the standing to sue in federal court. So this was before the Civil War, and they found that African Americans, even though many had been born in the United States, were not citizens and could never be citizens. And that's 1857. And then, as you know, the Civil War took place, and we had 3 constitutional amendments because our founding documents did not have an equality clause. And so the strategy is like, well, judges would understand. Judges are lawyers. So they would understand the importance of having education where people are together and they're getting the same kind of training. Because many in many places in the South, they didn't even have a law school, right, for Black people. You know, they had maybe colleges for Black people, but there were very few law schools for Black people at the time, in the beginning. And so he felt that judges could understand, they would understand what equal legal training meant, that legal training meant that you were with your peers, that you knew where the library was, that you would know who the other lawyers are, you know, in your community. You would know all of that. That's what legal training meant. That was what legal training was important. And so that was their strategy, and they did a number of cases beforehand, you know, to get to Sweatt versus Painter. So Sweatt versus Painter was a 1950 decision that dealt with Mr. Heman Sweatt. He was 33 years old, a former teacher, a postal carrier, and he applied to University of Texas Law School, and the University of Texas at the time did not admit people of African descent. And the Supreme Court decided 9-0 that this was unconstitutional, that this was not equal education for people of African descent. And what Texas had done at the time is Texas actually created Thurgood Marshall, Texas Southern University. It was created at this time to deal with this issue, to educate African American potential law school students. And the kind of facilities that they had for African American students was not up to par. And so the thinking was, in the strategy, NAACP, Thurgood Marshall, and others, is that we will show that separate, or even separate but equal, would not be equal, right? Because they had no access to the library. They had teachers from UT coming to Houston to teach. It was quite different than what the UT students went through. So 1950 is a very important year from our legal profession because we opened the door. Lawyers opened the door of access to people of all backgrounds to go to law school and start the process, because if you then let people go to law school of any background, well then, what about other colleges? What about undergraduate colleges? What about high schools? What about elementary schools? What about parks? What about pools? All of that would eventually fall. And then in 1978, so for all this period of time, you know, a lot of schools tried to open up access, do what was now perceived to be affirmative action, to make sure you had more people of different backgrounds go to law schools and other colleges. And you had the 1978 where the tide changed, and you had people who were not Black using civil rights strategy in order to have access. And so you had other applicants using Marshall's civil rights strategy. And in 1978, Alan Bakke challenged what was a race-based admissions policy, and it was a quota. that the medical school had. And he was a 35-year-old engineer, a former Marine officer. He was twice denied admissions to UC Davis Medical School. And in a plurality decision, the Supreme Court found educational diversity is a compelling governmental interest, but the university cannot use quotas to achieve diversity. And so since '78, people also were questioning that particular decision, because that decision, as I mentioned, was a plurality decision, where it means that there wasn't a majority of the court that decided it. You had a concurring opinion that everybody put their cap on to sort of say that's the law. And then Grutter, I'm going to zoom through because I want to get you to Dr. Simmons, but Grutter then affirmed this, said in 25 years, I hope this, Justice O'Connor said, in 25 years, I hope that we don't need to use this anymore. And in 2023, you have SFAA versus Harvard and University of North Carolina. And they turned back the affirmative action programs and said that race-based admissions, they must end. This is an opinion by the Chief Justice. But he said that military academies may continue using race-based admissions because a whole different story for them. Student body diversity does not meet strict scrutiny. But the Chief Justice did not expressly overrule precedent. He did, in his opinion, if you read his opinion closely, he does not overrule precedent. The dissenting opinions say he's overruling precedent, meaning with precedent you follow what the law was before. Or you follow what you are following what the law is before. It could have been decided on different grounds, this case, because at least what I read in the press, the way that Harvard and UNC were implementing the policy probably was unconstitutional or illegal, right, in terms of what the prior precedent was. You could have overturned it on narrower grounds, but they did not. But he also did not expressly overrule prior precedent. Now, that one of the dissents did, and so where are we with all of this? We have sort of a mixed area where you can use race or not. So the Chief Justice, we look at the middle square, he said in his majority opinion that nothing in this opinion should be construed as prohibiting universities from considering an applicant's discussion of how race affected his or her life. So he doesn't totally backtrack on the policy, but he says you can't use this as a substitute for affirmative action. But if a student or applicant wants to talk about this, how can you stop a student or applicant talking about this? With the military academies, he said there's potentially a distinct interest in terms of national security, is what he said. That in terms of, he wants a further factual record with respect to this. And in fact, the Supreme Court has denied cert in several cases dealing with this, even though lower courts have approved using race in military academies. And then on the left side, my left, or I guess your left, or my right, on this slope, the right, on the Voting Rights Act, they allowed some consideration of race. Now, will that will continue? I don't know. So we're in a mixed place where we are legally, where we are certainly transitioning from, and we've been transitioning from one place to the other for the past 50 years. It's been sort of slow, but it has been this transition, in my view, of going from one place to the other place. We have accelerated the transition over the past few years after SFFA. And the question really for me, and why I asked Dr. Simmons specifically to be here, is, she's a trailblazer, she's a barrier breaker, she's a star, she's an academic superstar. We really appreciate her being here, and she has been the first in so many places and has a wide world of experience in a variety of different things as academic leader. And I think that it would be helpful for her to talk a little bit about sort of how she positioned the universities that she was at from here to there, what her experience was like with a lot of these issues. And let me just read her bio briefly. There's so many accolades. It may take me 10 minutes, 15 minutes to read, but I'll try to be short. So she's now currently the Distinguished Presidential Fellow at Rice University and advisor to the President of Harvard on HBCU initiatives. She had served as president of Prairie View A&M, and prior to Prairie View, she was president of Brown University, and she was president of Smith. And under her leadership, Prairie A&M University was reclassified to a R2 research university, and Brown made significant strides in improving its standing in one of the finest research universities in the country. She was a French professor before entering university administration. She has a PhD in Romance Languages and Literature at Harvard. She served in many other academic positions, as I mentioned, Smith, which is the largest women's college in the country, which my niece, say hello, Denise, went to, so she's excited to see Dr. Simmons. She's a recipient of many honors, a Fulbright Fellow to France, the President's Award from Negro College Fund, the Fulbright Life Achievement Medal, the Eleanor Roosevelt Val Kill Medal, the Foreign Policy Association Medal, the Ellis Island Medal of Honor, the Centennial, and many, many honors. We are very delighted to have Dr. Ruth Simmons in the
My hair is kinky, my nose is wide, my skin is technicolor. I won't apologize.